everybody. We just celebrated Dr. Martin Luther King Day. There was a beautiful celebration on Monday, which I attended. And today I will be presenting on the housing issues that matter in our district, hopefully. So the first item would be NYCHA. And I have to explain that I do work for NYCHA. I work in litigation department as an agency attorney. I've been working there for almost 4 years. It's going to be 4 years in March. So let's talk about NYCHA. NYCHA was created. Okay, so this is our presentation.
I have to share it. 1 second.
Okay. We are working on the sharing feature. So NYCHA was created in 1935 during the times of Great Depression, to provide affordable housing to low and moderate income New Yorkers. And NYCHA is the largest public housing authority in North America. NYCHA is also the largest landlord in New York City, with approximately 8% of the rent housing stock. So about 564,000 New Yorkers, or 1 in 15 New Yorkers, live in NYCHA serviced properties. If NYCHA were a city, its population size would rank 32nd in the United States. So are we recorded? Can everybody hear me online?
Yeah. Yes, they're all muted.
Okay. So NYCHA charges rent based NYCHA charges rent based on household income and assigns apartments based on family size. As we all know, along Coney Island, NYCHA has Cary Gardens development, Haber Houses, Coney Island Site 1B, Oddwire Gardens, Gravesend Houses, Coney Island Site 8, Surfside Gardens, Coney Island, and Coney Island Sites 4 and 5. And I just want to praise a lot of people who work for these developments, the property managers, the assistant property managers, and numerous housing assistants, superintendents, and caretakers, assistant superintendents who diligently work every day in these properties. So NYCHA is a HUD subsidy. NYCHA's $3.8 billion annual operating revenue is largely comprised of public housing grants, operating subsidy from HUD, Housing and Urban Development, and Section 8 subsidy from HUD. Rental income is an estimated $1 billion, or 27% of annual operating revenues. If there is a shortfall in rent collection because of decreased rent payments, HUD, which is a federal agency, does not make up the difference. The HUD public housing operating subsidy is based upon NYCHA's ability to collect 100% of the rent charged to the tenants. If NYCHA fails to collect rent, or if the rent charged changes in the mid-year due to interim recertifications, there is no increase in subsidies to bridge that funding gap. Rent collection losses decrease NYCHA's day-to-day operating funds and NYCHA's ability to repair and preserve its buildings. NYCHA, like many public housing authorities nationwide, has experienced rental income losses during the COVID-19 pandemic, which means we under-collected rent. So a lot of people didn't have ability to pay rent, and we did have losses. Rent collection at NYCHA was already decreasing prior to the COVID-19 pandemic, but this trend has only been exacerbated. So let's turn to the page that talks about NYCHA's income and family composition and annual requirement. At initial application, once a person enters into a NYCHA apartment or public housing, and then going forward annually, every tenant is required to provide to NYCHA information regarding his or her income and assets for all adult household members for eligibility and rent setting purposes. So this is called annual recertification or annual review process. So it's a must, it's a requirement. During that process, people have to identify all household members or family composition, and then the rent is being recalculated. Next slide. A tenant may request that NYCHA recertify his income or the family composition between annual recertification periods by applying for an interim review or interim change. So let's say something changed in your family composition, your adult daughter moved out, or the son moved out, or somebody became unemployed, lost his job, there was a divorce. So you can always do an interim review or interim recertification to adjust your income and therefore adjust your rent, to lower your rent during mid-year. You might also have rent hardship. So, NYCHA would react accordingly, but you have to let us know. You either, like a person should either go to a management office to recertify and do an interim review, or they can do it online via NYCHA portal. Rent determination at NYCHA. After household income is determined, rent is based on income. Rent based on income is calculated per the HUD formula using the highest of. So it's either 30% of the household adjusted income, which is the most common, or the 10% of the household gross income, or the welfare rent, or the minimum rent, which at NYCHA public housing is 0. So next slide. After the rent based on income is determined, NYCHA sets the monthly rent at the lower of income-based rent or flat rent. Sometimes we have issues and people ask, how come my rent is not at 30%? So, and then we look at the family composition, and what happens often is that this household is so-called mixed citizenship household. And when there is a mixed citizenship household, the HUD does not allow us to calculate at the 30% of the household income formula. So we calculate the rent differently for the people who are not so-called ineligible non-citizen. Next slide. NYCHA's annual and interim reviews. At the conclusion of the annual or interim review process and after monthly rent is established, NYCHA will issue to the tenant the lease addendum and the rent notice. And the lease addendum will specify the next year rent, monthly rent. So also forgot to mention that once a person enters NYCHA as a tenant, they get a 12-page lease, and which is called initial lease, and this lease stays with them during their tenancy. However, once they recertify annually, they get a lease addendum. So unfortunately, sometimes there are NYCHA has to terminate this lease agreement, and we have tenancy termination proceedings at NYCHA. So before tenancy is terminated, NYCHA tenancy termination procedures require that a tenant is afforded the opportunity to cure the offense at the management level, if curable. And if it's unresolved, then there is an opportunity to go through an administrative process. It's called administrative due process hearing before an impartial hearing office. So why would NYCHA terminate the tenancy for certain tenants? There are different bases, and we have to go to that slide. Next slide, please. Over here. So there are different bases for termination. So one of the things why we do terminate is non-desirability. So it's a certain conduct or behavior in the apartment which might constitute a danger to the health and safety of the tenant's neighbors. So, for example, bringing a weapon would constitute a danger to the people, and this would be a basis for termination of tenancy along the line. Or the conduct on the vicinity. So sometimes we have sex offense crimes at the apartments. Also, a common law nuisance can be a ground for tenancy termination. So, as every landlord, NYCHA has a set of its own rules and regulations, and if somebody violates these rules, it can become a ground of termination as well. Another ground is chronic breach of rules and regulations, chronic delinquency in payment of rent. And the next ground is non-verifiable income. So as I mentioned earlier, people are supposed to recertify their income annually by going through annual review process. If they fail to do it year after year and they don't respond to NYCHA notices, it would become a ground of termination. So it would be called non-verifiable income ground if people do not go through the income verification process at NYCHA. Another ground for termination of tenancy is assignment or transfer of possession. So you cannot reassign your apartment or sublet your apartment to somebody else in NYCHA. It's considered illegal. And we do have cases when people leave the apartment. So let's say they go to their boyfriends, girlfriends, and they sublet the apartments. This is illegal at NYCHA because by definition, people got these apartments by waiting on the waiting list and going through the thorough review, the certain checks and processes. So there's no way to you can sublet the apartment at NYCHA legally. And when we do find out, it's a ground for termination. Also, misrepresentation is a ground for termination. If you conceal certain facts, certain material facts, or misstate certain facts, it can be a ground for termination. As I mentioned earlier, we do have a process, so we call it the due process. And before the tenancy terminated, tenants go through certain procedures. The first step is the interview at the property management office. They would talk either to the property manager or their housing assistant, and the tenant is given an opportunity for a face-to-face interview and discussion, and they're given the chance to cure the offense. So if this doesn't work out, then the second step would be going through the impartial hearing. I think it's the next slide. So impartial hearing, it's basically a hearing in front of administrative law judge, and the tenant may appear at the hearing with counsel, so they can be represented, or they can have a guardian ad litem, also called PAL. The tenant will have an opportunity to provide an oral testimony. They can submit written documents into evidence. They may cross-examine any NYCHA witnesses, or they can refute any NYCHA submitted documents. They can also be given a translator, so an interpreter is provided at the hearing, and we create a record of the hearing. The record is compiled. At the end of this hearing, the hearing officer, the impartial hearing officer, issues a final and binding determination. And then eventually that decision is adopted, and NYCHA issues a determination of status document, which represents the final NYCHA determination on the issue. So it's on the next slide. Oh, yeah, right. So the determination of status can be appealed at the New York State Supreme Court in Article 78 case within 120 days. Okay, so I spoke about annual reviews, the termination of tenancy proceedings, and the latest things that have been going on at NYCHA are NYCHA rental arrears assistance programs. So NYCHA households may be eligible to receive financial assistance to pay for a portion of their rent owed to NYCHA under the two new rent programs. One is called COVID-19 Rental Assistance Program, CRA, and it was administered in March of last year. And we still have an ongoing program called Home ARP, which stands for Home American Rescue Plan Program. This is a federal program given by HUD, the federal agency. And basically, these programs help people who fell behind on their rent, and they have huge rent arrears. So we have some tenants who owe NYCHA over 50,000, some owe NYCHA 70,000 in rent arrears, and hopefully these programs will help them out in the long run. So if a tenant obtains funds from Home ARP program, that tenant cannot be evicted for up to a year. So this is the requirement from HUD. Okay, yeah, I think we're done with NYCHA for now, and we'll talk about the good cause eviction law. So it's a new law which became effective in April of 2024. Why do we need this law? It provides protection to market rate tenants. So I guess you've heard about rent stabilized apartment, rent controlled apartments. And you might know that tenants there have a lot of protections, but there are a lot of apartments and a lot of tenants that are not protected under the New York state laws. So this new law does protect unregulated homes. And how does it protect? So first of all, landlords of housing units which are covered by this law cannot evict or refuse to renew a lease, or they must provide notice that the tenancy will end unless there is a good cause. So they have to give a reason. If you're a landlord, you cannot simply tell your tenant, that's it, your lease is over, I will not be renewing, and I want to evict you. So you have to provide a good cause in order to do this.
I have a question.
Yeah,
So when your lease is up, they have to re-sign your lease? Your landlord? They have to give you another lease? They don't?
If you live in the unregulated apartment right now under this new law, they have to give you a reason, a good cause. But there are exemptions, so there is a huge list of exemptions, and we'll go over it. So just be patient, please. Because a lot of people are protected under this new law. This new law also does not allow landlords to arbitrarily raise rent on the next renewal lease. So, and the rent increases should stay between 5% and 10% based on a certain formula that considers inflation. So last year's reasonable rent increases were about like 8.82%. And these increases, they're determined by the state every year. So tenants can use this new law as a defense in the housing court. So let's say somebody is being evicted and they're being called into the housing court, they're summoned there, let's say in a non-payment proceeding or holdover proceeding, and they can use this law as a defense.
So they don't have to pay their rent, let's say that's it.
Well, there are different protections. They can say, I want to stay in this apartment. I want my landlord to renew my lease, or I don't want these huge increases because these huge increases do not correspond to the rent increases that are allowed under the state law. So let's say it's a 20% increase. That would be out of the range because under the range, the landlords can increase from 5% to 10%. So last year it was 8.82%. So, and I've seen people who would show me their new leases where the increase was like 15%. So under this new law, this would not be allowed. So let's go to next slide. And what are these marks? Okay. So the good cause eviction law does not apply to everyone. And there are certain exemptions. It doesn't apply to the apartments that are already regulated. So for example, NYCHA apartments are considered already regulated. So it doesn't apply to NYCHA. It doesn't apply to project-based Section 8. It doesn't apply to rent stabilization laws because tenants there already have a set of protections and regulations. So let's take a look at the exemption. So there is a list of exemptions. So for example, if your apartment is a condo or a co-op, it's not protected under this law, unfortunately. Or if your unit is owned by a small landlord who owns fewer than 10 units at the entire New York state, again, you're exempt. The unit is exempt and you're not protected, unfortunately. So if it's a small landlord, then also if unit is a seasonal use dwelling, if unit is in hospital, then it's exempt from this law. If it's a hotel room, it's exempt. If it's a religious setting, it's also exempt. So people would start wondering, so what would be considered a good cause? And on my next slide, I have a description of what would count as a good cause. So if an apartment falls under the protection of this good cause eviction law, the landlord cannot terminate the tenancy and try to evict unless the landlord can show the cause. And I provide the list of causes. So cause number 1 is failure to pay rent that is not caused by unreasonable rent increases. So if rent increases are reasonable within that range from 5% to 10%, then it's okay. You have to pay your rent as a tenant. And the failure to pay this rent would constitute the good cause. So there can be also breach of lease, which tenant fails to cure. And we all know that every lease, every residential lease has a lot of paragraphs, conditions, and regulations, and the tenant should not be breaching them. So the tenant should not be a nuisance to his or her neighbors and should not be substantially damaging the property, and so on. So you can just examine this list. Also, there are protections for tenants who are under 65 and who are disabled. As far as failure to pay rent, owner must prove that the failure was not due to unreasonable rent. And there can be like certain proceedings where they would examine what's reasonable, what's not. The owner would have to show the proof why they raised the rent at a certain amount. For example, they would say, oh, I have to pay more for water or for property taxes. So they would have to substantiate the rent increases. So, and with this new law, there must be a notice. So when people are being sued in the housing court, there should be a notice attached to the rent demand, to the notice of petition. So litigants should be aware of this new law. So let's turn the page and talk about Housing Connect. So if you don't live at NYCHA and you're searching for an apartment, we do have a portal. It's called the Housing Connect 2.0. It's an online portal where you can find an affordable apartment or home to buy or rent. And affordable housing costs about 1/3 or less of your housing income. It's a lottery. You have to create your profile there initially, and then you start playing, and you can start searching for apartments in all 5 boroughs. So yesterday I looked at what's being offered over here in Brooklyn, and there is a new building, a very fancy building on King's Highway right now. Nothing is being offered over here on Coney Island, but we are well aware that a lot of new buildings were offered on Housing Connect in the past. Coney Island Phase 2 was on Housing Connect.
All their building in Coney Island is full now, so there's not a Housing Connect no more?
I don't think so. No, I don't think you can find them on the Housing Connect. But Coney Island Phase 2 was there, I think, a year or 2 ago.
So all the apartments are rented already? You said?
Maybe you should inquire by calling the office, but I think the initial offering
Oh,
is done, yeah.
It's done, so.
Yeah.
A new one.
Right. Right. So when you do go to Housing Connect, there is some priority. People with disability, especially vision disability or hearing disability, have priority. Seniors have priority. People who live in the same neighborhood where the building is being offered also have priority.
What's the age for the senior?
62 and up. Okay, and the last slide, since it's very cold right now, so we've been experiencing frigid weather, I decided to remind people of the HPD rules with regards to heat and hot water. So heat must be provided in all buildings between October 1st and May 31st. This is called the heat season. And during daytime, between hours from 6 a.m. to 10 p.m., if the outside temperature falls below 55 degrees Fahrenheit, the inside temperature is required to be at least 68 degrees Fahrenheit. At night, it can be lower. So between the hours of 10 p.m. and 6 a.m., the inside temperature is required to be at least 62 degrees Fahrenheit. So I hope everybody's staying warm in the apartments. If you do have issues, do not hesitate and call 311. And just say my landlord is not heating properly. So,
That's why I have to put the, that's why I have to.
I don't know how.
Closer to,
Sorry.
that's why I have to put the sheet closer to, closer to here. because it's always cold in my room. That's for sure. And I couldn't sleep. I couldn't sleep well. I couldn't get up and function. So that's
So do
why.
you have an electric heater or do you have radiator?
It's not. I have a heat reservation, but it's not. It's not heating up. It's not heating up.
It's not hot enough?
No.
Okay.
If there was any, sometimes in the rooms, they have to fix the windows. Fix the windows.
see him
so
the
they
room.
keep it safe,
That's okay, I know.
Like around insulation. They have to put insulation. And if they don't. It's a waste of time.
There's a question on Zoom.
Okay.
I have to unmute her. 1 second.
Oh, Lucy wants to ask.
Hi, Tatiana. Thank you for the presentation. I
You're
have,
welcome.
I have a question about housing and just, this is more curiosity for me. Is there a max income? Because if housing is supposed to be low income and after you're in there, hypothetically, you get very lucky and you're making a couple of more dollars. Is there a max income that they can evict you?
Yes, we do have a max income and we've been having special proceedings and we're going after tenants that do not want to pay the adjusted rent. So if your income, I believe, higher than 120,000, the rent will be recalculated and the tenant would have to pay a market rent.
But they can't be terminated.
If they don't comply, then they will go through the termination proceeding, but they will be afforded to everybody.
But if they do comply, they can remain there if they make 200,000.
Right, yes, yeah, they will get a notice that your rent, I mean, your income is too high, and they will be offered an opportunity to pay market rent.
All right, I'm not blaming you, but I think that's kind of silly because it's supposed to be low income housing, but that's just my personal opinion. As the second presentation that you made, you were talking about how landlords can increase rent. Isn't there like a standard, percentage that landlords could only raise your rent based on whatever lease they provided to you, a 1-year lease or 2-year lease? Because I think you said somebody can come and say, I'm going to raise your rent 15%. But isn't there a standard percentage? And if they want to raise it to 15, I believe you said they have to justify why.
Okay, so there is a standard percentage if you live in a rent stabilized apartment and you have a lease which says it's covered, it's protected by rent stabilization law. It's usually on top of your lease.
Mm-hmm.
Then there is a table which shows that if you sign a rent renewal, a lease renewal for 1 year, then your rent will go will increase by such percentage. If you sign a 2-year lease renewal, then your rent will go a little bit higher. But we are talking about market rate apartments, which are not regulated. They are not rent stabilized. They are not covered by rent stabilization law.
So if I live in a 2-family home and he gives me a 2-year lease, and the following year he says, hey, I'm going to raise it up 30% because, my taxes are outrageous and my water's outrageous. Obviously, he has to justify it, but he or she can do that.
Yes, if they're
Wow,
considered a
okay.
small landlord who has less than 10 apartments in New York State, they can do it, yes.
Okay, thank you so much for answering my question. Appreciate it.
So small landlords are not covered by this good cause eviction law.
Do not
So,
answer.
But
Can you mute it?
if the landlord has more than 10 apartments, then they should comply with this new law. Also, if you live in a condo, co-op, if the condo cope is being subletted, unfortunately, copes and condos are also exempt from this new law. Good cause of
Do you want me
eviction.
to stop sharing the screen? Can I stop sharing?
Yeah,
Can I
sure.
take this off? Okay, thank you.
So, and I also want to mention that at NYCHA, we've been doing a lot of repairs right now, and the buildings are old, and a lot of buildings have been built in the 1950s or 1960s. And sometimes there are a lot of defective conditions, and people complain about their vinyl floor tiles. So what we do right now, we often have to relocate families temporarily to remove asbestos under their vinyl floor tiles. If the floor tiles are defective, damaged, or broken. So this has been happening. There is a big trend right now in niche housing. We locate the family temporarily. We abate asbestos in the floor tile. We put the new tiles without any asbestos, and then the family comes back to their newly fixed apartment. So we also have a special department. It's called Healthy Homes. And in addition to abating asbestos, they also look into issues of mold and lead. So we do a lot of testing for lead-based paint. And if we do find lead-based paint, again, we relocate the family temporarily, and we abate the paint. So we remove the old layers of paint, and the apartment would be plastered and painted again with the new paint, which does not contain lead. So we take these harmful substances seriously, and we take a lot of precautions right now. Any questions? Mark?
No, Mark's up there. Oh, looks. No, doesn't have. We can't, hold on a second, hold on. That's up to the chair. If you have anything
Okay.
else to discuss, what would you?
Any questions? I can also discuss copes and conduits. So I live in a cope, and I happen to be vice president of my board. So if you have any questions with regards to cooperative buildings, you can also ask. So I guess we don't have any questions in the room or online, until we can
Mark
finish.
Bernick has one, but I'm.
Oh, Mark has a question? Okay.
Yeah, just a clarification.
Yeah.
This is called the Fair Good Cause Eviction Law,
Right.
and it would apply to small homeowners also.
No.
No. And let's say it's not
Small-
eviction, you're just raising the rent, and I say, well, F you, I'm not paying, take me to court. So what exactly has changed in terms of that? And do you have any idea what any of the new stuff that the either Mandami or the governor impacts that. And
Well,
I'll
yeah,
wait for
I'm
the-
not sure about the new administration. It's very early right now to say anything about the new administration, right? We just had an inauguration of Mayor Mamdani. So I'm sure there will be new developments in the area of housing law, and the new laws will be passed. But the good cause eviction law sort of protects very small landlords who have less than 10 apartments. So let's say I'm a small landlord, I have a few buildings, and I have less than my portfolio has less than 10 apartments. I will be exempt from this law. But if I have 20 apartments, I will not. So this law does provide protection for a number of market rate tenants, but there are holes in this law, and I guess it was very hard to pass it at the state level, and therefore we have exemptions.
Okay, thank you.
Okay, so the
Excellent.
meeting is adjourned. Thank you everyone for coming.
Oh, it's presentation.
Yeah. There's no new business, old business, right? So there's nothing to.